We know that teachers and school administrators exercise substitute parental authority over our children when they are within the school premises. But who should be liable should one of these students gets into harm's way on a Saturday within the school's premises? Jose is a graduating high school student. One Saturday, Jose went to school to submit his science project. He was seen to have stayed further and was lounging around with his classmates. Before Jose was able to head home, Jose was hit by a bullet of a gun which was fired by another student, Pablo. Jose died as a result. Jose's parents were asking the court to make the teacher in charge and even the school liable for the death of Jose on the ground that the teacher in charge and the school was supposed to have been exercising substitute parental authority over Jose. It was contended that the teacher in charge and school have no liability because it was a Saturday and classes have already ended to give way to the summer vacation. May the teacher in charge and the school be held liable for the death of Jose. According to the Supreme Court in a similar case, it is said that it is too tenuous to argue that the student comes under the discipline of the school only upon the start of classes. Neither should such discipline be deemed ended upon the last day of classes, notwithstanding that there may still be certain requisites to be satisfied for the completion of course, such as submission of reports, term papers, clearances, and the like. During the periods, the student is still subject to the disciplinary authority of the school and cannot consider himself released altogether from the observance of such rules. During all these occasions, it is usually the teacher in charge who must answer for his student's torts, in the same way that the parent are responsible for the child when he is in their custody. The teacher and not the parent shall be held liable if the tort was committed within the school premises. The school may be held liable to answer for the acts of its teachers, but may be exonerated from liability by proof that it had exercised the diligence of a good father of a family. In the case of Jose, it is important to look at the surrounding circumstances. At the time that Jose was shot, he was still in the custody of the school, notwithstanding that classes have ended. He was in school for a legitimate purpose, for the submission of his science project. Even if the teacher in charge who exercises substitute parental authority over its students, there was no showing that such teacher in charge was negligent in enforcing discipline over Pablo or that he had waived the observance of rules and regulations of the school. If there should be anyone who may be held liable, it may be the dean of discipline of the school who was supposed to have exercised utmost diligence in ensuring that no deadly weapons are brought within the school premises. In this case, the school and the teacher in charge were not held to answer for the actions of Pablo, as none of them was found to have been in charge of Pablo or has been remiss in the discharge of his duty. If you have any questions regarding your legal concerns that are not yet pending before the courts, please do not hesitate to email us at ptv4newscenter@gmail.com. This is Attorney JJ Jimeno Atienza for the Rule of Law.